go and keep moving forward with our ideas about laws and regulations relating media. And I told you guys last time, we're going to start off today by talking about the Patriot Act. And I encourage you to do a quick Google, if you could, about what the Patriot Act is. And also to warn you ahead of time that it's one of the things that makes me maddest in this world. So what is the Patriot Act? Well, first of all, notice that it is all capitalized. And that's not, I'm not yelling at you. I'm not Donald Trumping you. It's all capitalized because it's an acronym, right? Each letter is representative of a word. It actually stands for providing appropriate tools required to intercept and obstruct terrorism act. In fact, the full name of the act is the USA Patriot Act, which is actually uniting and strengthening America by providing the appropriate tools required to intercept and obstruct terrorism act. The Patriot Act was passed in 2001 originally. It was passed actually within a month of 9/11. So less than a month after the terrorist attacks of September 11th, the United States government had written and approved a bill designed to, on its face, provide appropriate tools required to intercept and obstruct terrorism. Well, what the hell does that have to do with us? This isn't a criminal justice class. This isn't a political science class. What does that have to do with media? Well, the Patriot Act gave the federal government unlimited and unrivaled powers to do things it was not able to do before as it regards to mediated communication. One of the most notable things that was done is that it allowed for the federal government to secure the internet usage report from any public computer. And the number one place people use public computers is in a library. And the completely unsung heroes of this are librarians. Believe it or not, librarians fought vehemently and continue to fight vehemently. You want to piss off a librarian? Mention the Patriot Act. They get mad. And it's hard to get a librarian mad. Their entire job revolves around being quiet, but they will get mad if you talk about the Patriot Act, because it basically discouraged people from using public resources to investigate anything they were curious about. It put a muting effect, it put a stifling effect on people's engagement with digital media, because now the government could get those results without a warrant, right? There are a lot of other concerns with the Patriot Act, all of them dealing with privacy for the most part. Aside from the fact that it's an incredibly ineffective bill, it doesn't actually help anybody intercept or obstruct terrorism. But what it does do is make it really, really, really easy for government actors and government officials to look into your web history, look into your email, look into, I mean, it really destroys the Fifth Amendment. In the Fourth Amendment, excuse me, in multiple ways. And so the Patriot Act was a big deal for media because it really dampened people's desire to use the internet. Obviously didn't dampen it so much that people don't use it, but it made it it added a whole new layer of civil liberty concerns when it comes to using, what is arguably one of the greatest resources, society has ever come up with for spreading information. One of the most significant court cases that we're going to talk about happened in 1957, and it was Roth versus the United States. This is one of the cases that is available for you to pick for your media law analysis paper. You are able to do this as one of the cases if you're so interested. So if nobody's called dibs on this yet, after you hear the description, it might be something you're interested in. Quick claim dibs if nobody else has. So what is the Roth v. United States case? The Roth versus United States Supreme Court finding is all about obscenity and what constitutes obscenity in the United States. And more to the point, is obscenity protected, right? One of the things we've mentioned a few times in this class is that the First Amendment gives you 5 protections. freedom of religion, freedom of assembly, freedom of petition, freedom of press, and freedom of speech. It wasn't until 1957 that the Supreme Court finally weighed in on whether or not things that were considered obscene were protected by the First Amendment. Is obscene speech protected speech? That's the root of the question in Roth v. US, right? So what came about, right? The Supreme Court, the background of the case, I'll let you research on your own if you're interested. But what is the finding? What's relevant here? Essentially, the Supreme Court ruled first and foremost that the First Amendment does not protect obscenity, right? According to the Supreme Court in 1957, obscene speech is not protected by the First Amendment. And again, you can look up the ruling, and the court, a majority opinion will explain their reasoning, explain how they came to that conclusion. Why do they feel it is not protected by the First Amendment? But that was what they found, right? And again, as mentioned on Monday, that becomes law of the land then. That is how all other courts are required to adjudicate cases, is based upon that finding. So from 1957 onward, obscenity has not been protected by the First Amendment. Well, if that's the case, right, what in the hell does obscenity mean, right? Obscenity for most of us is a pretty subjective idea. What you consider obscene probably isn't the same for somebody else. So if you're going to limit someone's rights, you better have a really clear explanation of not only why, but what in particular you're limiting, right? What part of speech is considered obscene? Well, the court defined obscenity as material, quote, this is a direct quote from the finding, utterly without redeeming social importance. I don't know that makes things clearer, right? Utterly without redeeming social importance. I'm not really sure how that makes the concept of obscene more concrete, right? How does that make it less subjective? Because again, just as you and I could disagree on what's considered obscene, I think you and I could reasonably disagree on whether or not something has social importance, right? If I make a giant sign that says "fuck the government," does that have social importance, right? You might agree or you might disagree, but which one of us gets to make the final judgment, right? So that's still not doing us a lot of favors. But fortunately, the Supreme Court went a little bit further, and they established what has come to be known as the Roth test, right? And the Roth test, named after the defendant in this case, or the plaintiff, I should say, named after the subject of this case. The Roth test is a simple test that the court designed so that for future matters, for future questions of whether or not something is obscene or utterly without redeeming social importance, how can we test that, right? How can we give us some kind of a template we can apply to this scenario to say, does it fit, right? Does it constitute obscenity? And the Roth test is defined by the court as, quote, whether to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to prurient interest, right? And I broke it up that way on purpose, right? I broke it up by phrase deliberately because we need to really, when you're dealing with something this lengthy, this convoluted, you gotta take it a chunk at a time, right? So number one, whether to the average person, right? I don't know if you've had a lot of interactions with judges in your lifetime. Some of you probably more than others. Yes, Mike, I'm looking in your direction. If you've had a lot of interactions with judges in your lifetime, one of the things you can figure out very quickly is that they're not normal people, right? To be a judge, number one, you have to have a law degree, right? Number two, you're probably a bit up there in age because judges are usually either elected or selected because of a track record of legal action, because of a track record of being a good attorney, right? And they're not poor, right? Judges aren't poor. So those are three basic requirements of the job that automatically disqualify you from being an average person, right? So first and foremost, the Roth test says, all right, judge, before you can determine if something is obscene, you have to stop thinking like a judge. You have to start thinking like a schmuck. You have to start thinking like an average Joe, right? And once you start thinking like an average Joe, you have to then apply contemporary community standards, right? If you're a judge in Tacoma, Washington, there are very different social taboos and social acceptances than there are in Brooklyn, New York, right? If you're a judge in Little Rock, Arkansas, right, the standards of that community are grossly different from the standards of Miami, Florida. And even if you are a judge in Miami, Florida, there's a huge difference between what's considered acceptable today versus what was considered acceptable in 1952. So the court argues that if you're going to deem something obscene, you have to, number one, think about it from the normal person's perspective. And number two, apply the standards that the average person in your current community would apply, right? You can't say that something is obscene because your mother would have found it obscene, right? It has to be right now, here now, today, in this area, would that thing be considered obscene? After that, you have to determine if the dominant theme of the material, not just a theme, but the dominant theme. If you're dealing with a 600-page book and there's only one mention of an obscene word, is that the dominant theme? Or is that just a segment? Is that just a snippet, right? Does the dominant theme of the material as a whole, right, as a whole, not just one part, but the whole thing, is all of that appealing to prurient interest? Well, prurient is a word that you will probably never hear again in your life outside of this context, right? You would never hear the word prurient outside of a discussion of the Roth test. It is a real word. They didn't make it up for this case, but it's just an incredibly obscure word. What does it mean? Prurient means obsessively sexual. So, in other words, in 1957, in their findings of Roth versus United States, the Supreme Court argued that if you, as a government entity, want to censor material on the basis of obscenity, if you want to prove that this thing shouldn't be shown to people because it's too obscene, you have to prove, you have to establish that the normal, average, everyday person in your neighborhood is going to watch this movie and immediately think it's nothing but sex. If a normal, everyday person in your community would see this thing, would watch this thing in its entirety and find it to be nothing but sexual in nature and like gross sexual, right, in nature, then it's obscene and it's not protected by the First Amendment, and you don't have a right to perform it. You don't have a right to view it. That's not easy. It is not easy to prove that standard at all. That is a difficult bar to clear, but it exists and you can clear it, right? You can, in fact, have something deemed obscene because once you establish a standard for what is considered anything, right, you're basically giving people a roadmap on how to meet it, right? So there have been works that have been censored for obscenity in American history, and they were upheld as being obscene because of this standard, because they were believed that the average person would look at this and say, as a whole, it is prurient in nature. Well, and again, as I mentioned on Monday, when you're dealing with case law is the law of the land until the Supreme Court overrules it with another case, or Congress creates a new law, or specifically an amendment to overrule it, right? Well, in 1964, just a few years later, we see our next major case when it comes to defining obscenity in the United States, and that's Jacob Ellis versus Ohio. Right? Again, I'm not going to go into the background of the case. Not going to go into what got it there. You're more than welcome to look it up if you want. And again, one of the cases that you can pick for your media law analysis paper if you're so interested, right? But what Jacob Ellis versus Ohio found is that films, specifically film, cannot be banned by a state unless they are overtly obscene. So the Supreme Court is making it even harder to censor something now, right? Now they're saying if it's a film, right, you have to prove it is like more than just prurient. You have to prove it is like insanely prurient, right? You have to prove it is just over the top sexualized. Justice Potter Stewart, who was one of the justices on the Supreme Court at the time, wrote in his opinion that the Constitution protects everything except, and this is again a direct quote from the Supreme Court, hardcore pornography. So if you're ever on Jeopardy and they ask you, has the Supreme Court ever mentioned hardcore porn? The answer is yes. In 1964. What's really fun too is just, if you can, just really quick, Google Potter Stewart and like look at the images. Look at this old man, right? This weird ass old man who probably looks like some of your grandpas. Like, this dude is writing about hardcore pornography for the Supreme Court. So I think that's funny because like Supreme Court's all serious and, you know, prestigious, but talking about hardcore porn. Anyway, in the Jacob Ellis versus Ohio case, Potter Stewart wrote what is probably one of the most famous lines in the history of Supreme Court decisions. In the history of writing from the Supreme Court, Potter Stewart wrote in Jacob Ellis versus Ohio, "I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthand description, and perhaps I can never succeed in intelligibly doing so. But I know it when I see it. And the motion picture involved in this case is not that." So there are multiple layers, multiple layers of what the fuck is going on when we look at the phrase, "I know it when I see it." Number one, again, Potter Stewart, this old ass grandpa in the court, is telling us that he can identify hardcore pornography, which is, oh God, he's probably telling us too much. But the other thing that's really important about that and why it becomes so significant in history and why it's so remembered in history is it's not very helpful, right? It's not very helpful. If I'm a filmmaker and, you know, I want to make sure that my film doesn't get censored, I want to make sure that my work is not blocked from the public. This doesn't give me a lot of clarity on which direction I should go, right? How the hell would I know if Potter Stewart thinks it's hardcore pornography or not? Right? That doesn't help. I mean, yeah, I have the Roth test, but again, there's a lot of subjectivity in that as well. This doesn't exactly narrow it down. This doesn't exactly make it easier for me to figure out what is or is not accepted. Right? It also doesn't give a lot of leeway, or excuse me, it doesn't give a lot of guidance, I should say, to other judges. Right? Judges that are deciding cases on obscenity after this decision, they have to use this decision as their basis. They have to use this finding as okay, this is the law. Well, if they don't have a lot of clarity on what is that, what does that mean, you're going to get a lot of unfair application of the law. You're going to get a lot of unequal application of justice, which is, you know, kind of the antithesis of what the legal system's supposed to be, right? So fast forward another few years, not very long after that, in 1973. And in 1973, you get Miller versus California. In Miller versus California, the court argued that they took the Roth test and they took Jacob Ellis versus Ohio and they brought it another step forward. And they said, okay, censorship is possible, right? Whether this is a book, a magazine, a film, a radio show for that matter, right? You can. The state is allowed to censor material but only if, number one, it does not pass the Roth test, right? So we already had the Roth test established to determine obscenity, but in 1973, the court says, okay, but that's not enough. The court argued that there are things that could fail the Roth test, but still not be obscene. As of 1973, the standard is it has to first fail the Roth test. Secondly, it has to depict or describe in a patently offensive way, patently offensive, unquestionably offensive way, sexual conduct specifically defined by the applicable state law. Well, that's a weird addition to the end of that sentence, right? Specifically defined by the applicable state law. What is that talking about? It means in 1973, there were states in this country that had laws against certain sexual acts. You probably don't have to think really hard about who those laws were targeted at. In one of the saddest indictments of the American legal system, those laws were not overturned at the federal level until this decade. Right? It's been within your lifetime that the federal government said you cannot outlaw homosexuality. They're called sodomy laws. And in some states, like Louisiana, for example, sodomy laws were so broadly defined that sodomy was defined as anything other than traditional sex between a husband and wife. In states that were that broadly defining sodomy, it was illegal to have sex with someone you weren't married to. It was also illegal to do something other than traditional sex with someone, whether you're married or not. Right? That was still the law of the land in 1973 in a lot of states. It wasn't until the Supreme Court ruled on a case out of Texas, again, within the last 10 years, that they finally ruled that, yeah, states can't do that. You can't outlaw sexual activity between consenting adults. So in Miller versus California, the court argues that you can only censor it if, number one, it fails Roth, right? It is the normal, average, everyday person in your neighborhood would think that this is really, 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 really hardcore. And the act that's considered hardcore is not only illegal in your state, but is described or depicted in a very absurd way. And not only that, but also the work taken as a whole has to lack serious literary, artistic, political, or scientific value. And this is what has come to be known as the lapse test. So with Miller versus California, the court has made it really hard to censor material based on the concept of obscenity. Based on the findings of Miller versus California, think about all of the hurdles you would need to clear, right? If you're a prosecutor, right? You're a district attorney for Northern Illinois, and I make a movie and I want to show it at the Lindo Theater, and you think it's just absurdly horrible and obscene. It's incredibly offensive to anybody and everybody. And so you tell me I'm not allowed to show my movie at the Lindo. Well, if I challenge you in court, if I then, take that to court and say, all right, you're denying me my rights, you're denying me my First Amendment protections of free speech, you as the prosecutor, you as the government have to prove that, number one, the average person in Freeport, Illinois in the year 2020 would watch my movie and think it was hardcore porn. And furthermore, you'd have to prove that that movie shows something really absurdly offensive that violates state law, and also prove that my film has no literary value, no artistic value, no political value, and no scientific value. If those are all the things you need to prove to stop my film from being shown, it's a lot easier for me to defend why my film should be shown. If I make this film and you hate it and you think it's grossly obscene, but I use beautiful cinematography, I could just argue all day long it has artistic value. I can argue all day long that look at this. Look at what I'm doing with light. Look at how I'm painting with light in this scene. That people need to see this so they can appreciate the artistry involved. Right? The takeaway from this is that as it stands right now, because Miller is the end of obscenity court cases in the United States, or well, of interest at least. Miller is the standard to this day. If a judge is going to determine if something is obscene, they use the Miller v. California finding as their guide. So the takeaway is that as of today, it is really, really difficult to censor obscenity in the United States. You can draw your own conclusions about that, but I will say for me, I'm so fucking glad. I'm a big fan of allowing obscenity to not be censored. I don't know if you guys could tell by my language choice, but I'm a big fan of free speech. I really appreciate being able to say shit people don't like. And I think everybody else should be able to too. And I think one of the justices actually wrote I think it was in Miller v. California, in the decision, one of the justices wrote, we shouldn't be disallowing adults to view adult material because a child might see it. Right? The justice was essentially saying that, we can't make all entertainment G-rated because adults can handle more than G-rated stuff. And we should be allowed to handle more than G-rated stuff. We can't govern to the lowest common denominator. We can't censor to the lowest possible way. We need to allow people to make their own choices. So I'm a big fan. I'm very happy with where the court has gone with this through history. I think, if that's your thing, go for it, man. I don't know why it's the government's responsibility to step in there, but then again, I'm not a dick. So I don't know, maybe that has something to do with it. In 1988, the Supreme Court hears another case, shifting gears here, Hazelwood versus Kuhlmeyer. Right, so we're done with obscenity. The Supreme Court's last case about obscenity was Miller. Again, not the last case, but the last case of importance to us. So in 1988, the Supreme Court hears the case of Hazelwood versus Kuhlmeyer, which was regarding a high school principal who attempted to exercise prior restraint on the school newspaper. Right. The background of the story is that the school newspaper wanted to do a story about teen pregnancy and the effects of teen pregnancy on the student and, the realities and all this. And they interviewed a student who was at the school, who was a teen mom. And they had her permission, right? She was on the record. She knew what this was for. But when the principal caught wind of it, heard that they were going to write the story, the principal said that no, he didn't want that story going in the newspaper. It was going to be too harmful to the student. He didn't want the student body to know all this information, blah, 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 blah. And so the principal stopped them from publishing the story. Well, one of the students, who was 18, because you don't have rights till you're 18, argued that the principal was violating their free speech. Not just their free speech, but their freedom of the press. And went all the way to the Supreme Court, where the court ruled that schools can actually exercise prior restraint, but only if the school provides funding for the publication. So if a school newspaper is paid for by the school, then in essence, the principal is the editor, and the principal has editorial judgment, just like an editor of a newspaper would. But if the newspaper is self-funded, right? If the school newspaper is paid for by, direct contributions from the students involved, or by selling ads, in that case, no, the school has no right to censor it. You can do what you want. The school can't say anything about it. Since this occurred, since the finding in 1988, 10 states have written laws prohibiting prior restraint and protecting students and advisors. Right. So in 1988, the Supreme Court makes it the law of the land that if you're a school-funded operation, then the school can censor you. Well, again, the way you get around Supreme Court findings is either you write new laws or the Supreme Court overrules it in a new finding. So 10 states went with the first option. They wrote laws specifically prohibiting the behavior. So now, in those 10 states, that's it. You cannot censor student journalists. And I'm very happy to report that our very own Illinois did this in 2016. In 2016, Illinois officially signed the law that said that prior restraint on school newspapers is not allowed, whether they're funded by the school or not. Guess what, kids? Community colleges in Illinois. That means our school newspaper does not need any permission from the administration to run any story we want. As the advisor of the school newspaper, I'm here to tell you, they really don't like that. They are really not happy about that decision. I, on the other hand, am fucking thrilled. It's one of the few joys in my job is that, we do a weekly television show when we have enough students, right? We do a weekly news show. And if those students want to do if they want to do a whole 30-minute show about how corrupt the board of trustees are, there's nothing they can do about it. And again, as a First Amendment person, as a guy who likes the First Amendment, as a guy who thinks freedom of the press is important, as a guy who really believes in the Fourth Estate responsibilities of the press, man, is that fucking great. To know that if nothing else, at least student journalists can hold college leadership accountable without fear of retribution, without fear of repercussions. That's not even a protection I have. Right? As a tenured faculty member, I am not promised to be free of retribution or free of retaliation. I do not have the right to say whatever I want about the college's leadership. I don't have a law protecting that. But as the advisor of the news programming, I do. As a student, you do. And the fact that that only exists in 10 states out of 50 kind of bothers me a little bit, right? I get that it's the popular thing right now to hate Illinois, and a lot of people are like, "Oh, I can't wait to get out of this place." There are things you're allowed in Illinois you're not allowed in other places, and you should probably be a little bit more appreciative of that. Um, I think not enough students take advantage of this, and not take advantage in a manipulative way, but I mean not enough students realize that they are protected in their speaking truth to power. They're protected. It's not like high school, right? I realize that's a lot of the problem is that in high school, if you went to a school board meeting and you said my principal sucks, they're doing a shit job, they're wasting school money, they're they have no idea what they're doing, they're terrible to students. Yeah, I get how that you'd be afraid to say that because of course they're going to be dicks to you after that, right? They're every minor infraction you have, they're going to come after. I get it, but you're in college, you're an adult, you're not required to be here. The only power that a high school administrator has is the fact that you can't get away from them. That's not true at the collegiate level. If you think the dean or the president or fuck, even your faculty member, if you got a problem with them, say it. Say it loud, say it proud, say it to anybody who will listen to you because you have protections. And because you aren't stuck with them, you are not required to be in any person's classroom ever. In K through 12, it's the law. College is entirely voluntary. And not enough students recognize the protections that they have and what they can do with those protections. How much they can be self-advocating. How much they can really change. And in Illinois, those protections are even stronger. The next major topic when it comes to laws and regulations on media in the United States is what we call libel. It deals with libel. Libel and slander are often kind of discussed together. And the distinction is that libel is written, slander is spoken, right? And the way I always remember that is the alliterative slander spoken, the SS alliteration, right? Slander is spoken, libel is written. What is libel? Libel is a written statement that unjustifiably exposes someone to ridicule or contempt. So if I justifiably expose you to ridicule or contempt, it's not libel. Right? If you kick a puppy and I call you an asshole, it's not libel. Like I said, the difference here is that slander is spoken. Right? Libel is written and slander is spoken. Now, the laws relating to libel and slander are pretty much the same. There are very, very, very minor differences in the eyes of the law between libel and slander. But we're going to focus on libel because of that's usually what's brought up in cases regarding media is libel. The reason it's most often brought up is because libel is a lot easier to prove because it was written down. It's written down. I can prove that you called me an asshole. Look, it's written down. If I'm just walking down the street and you call me an asshole, it's really hard for me to prove that you called me an asshole. Right? But if you write in the newspaper that I'm an asshole, it's really easy to bring that to court and be like, see, look, right here, he called me an asshole. All right, so we're going to focus on libel, even though the laws regarding libel and slander are very, very, very similar, almost identical in most cases. And the first major case that deals with libel that we need to know about is the New York Times versus Sullivan from 1964. And this is a case that even if you aren't in a media studies class, even if you aren't in an intro to mass comm class, this is a case I think that everybody should know because of its historical significance kind of on a broader scale, right? So New York Times versus Sullivan is a case that revolved around an ad that was published in the New York Times, right? It was an editorial ad published in the New York Times based on the arrest and imprisonment of Martin Luther King, right? Basically, during the civil rights movement, Martin Luther King and a lot of other civil rights leaders were arrested on a pretty routine basis, right? It was a normal course of action for them to be arrested and put in jail because racists didn't like them. And they would find ways to make what they were doing illegal. Well, one of the times that Martin Luther King was imprisoned, this group of people took out an ad, an editorial ad in the New York Times, full-page editorial ad, where they criticized all of these political leaders, all these elected officials who had imprisoned Martin Luther King, right? On really just kind of trumped up nonsense to make him capable of arrest. Once that editorial ad was published, several of the people who were named decided, hey, you're being mean to me. You're making me look bad. I'm going to sue the New York Times for libel. And so they did. They sued the New York Times and said, yeah, you're defaming me. You are unnecessarily casting aspersions towards me or ridiculing me. And you're making me look like a jerk. And you shouldn't be making me look like a jerk. The Supreme Court ruled, number one, it wasn't libel, right? This was not libel. And they ruled that it wasn't libel because of this standard that they didn't really create. They just kind of identified it and codified it, called the standard called actual malice, right? And what actual malice is the idea that if you're going to say that a public official is the subject of libel, then you have to show that the defendant, in this case, the New York Times, right, to libel a public official, the New York Times must, number one, publish information that they know is false, right? They know that what they're saying is not true. Or they did it out of reckless disregard for whether it was true or false. So what are the pieces here, right? Number one, this only applies to public officials. In other words, elected people, government people. If you work in government through elected office or through hiring practices, you are a public official. And the Supreme Court has held many, many times that if you're a public official, you need to be scrutinized by any and everyone who comes along, because that's how democracy works. That's how a civil society operates, is that public officials are not above everybody else, but rather they should be more scrutinized than anyone else because they have the public trust. So if you're going to accuse someone of libeling a public official, then you have to prove, right? The person who is accusing libel, you have to prove that they ran that information knowing it was a lie, or they just didn't do their job. They just didn't do their due diligence. They didn't look into whether or not it was true. So let's say that Highland News Now, the Highland 30-minute weekly news program. Let's say Highland News Now runs a story that says Jody Miller, the mayor of Freeport, spits in all of the ice cream before they sell it at Union Dairy. And Jody Miller hears this story, watches this story, and says, "You sons of bitches. you're casting aspersions on my name. You're damaging my reputation in unfair way. You committed libel. And Jody Miller sues Highland News Now for libel. In that instance, Jody Miller has to prove either A, we knew that wasn't true, or B, we didn't really look into it. We just ran with it without really researching it, without fact checking it, without verifying it. If she can prove that we did one of those two things, then she wins. Yes, we committed libel. Shame on us. We're bad people. But think about how hard that is to prove. How hard is it to prove that somebody knew they were lying? You have to know what that person is thinking. That's one of the most impossible things you can ever establish in a court of law, is someone's mindset. It's easier to prove they didn't do their job, right? It's easier to prove that because you can say, okay, well, how did you trace this down? How did you run down this story? Oh, well, so-and-so told me that Jody Miller did it. And then I called several other people who work there and they all said that they think she does too. And so there you go. That's why we ran the story. Well, in that case, I've done my job. I have multiple sources who are all kind of telling me the same thing. Well, there you go. I haven't libeled Jody Miller because I had multiple people say it. Now, on the other hand, if I run the story and Jody Miller sues us and says you've committed libel, and I get on the stand and they say, okay, how did you source the story? How did you verify it? And I say, oh, well, I was at the YMCA and I heard somebody say it. And then I figured, you know what, that sounds like her. And I went ahead and okayed the story. Yeah, I lose on that one. No doubt about it. Right? I had reckless disregard. I heard a rumor and I ran with it. That's not doing your due diligence. That's not showing concern for truth. That is me wanting to say something bad about the mayor of Freeport and not caring whether or not it was true. So again, it's hard to prove libel, but not impossible. Not impossible. Just really difficult. All right, it is 10:49. So before I get yelled at for going over, we'll stop it there. I mentioned on Monday too, guys, that we're way